So you're thinking about starting a business in India. Fantastic. But before you do anything else, there's a huge puzzle you have to solve first. How are you going to structure your partnership? Now, it sounds like a simple choice, but as we're about to find out, getting this one decision wrong could have some pretty devastating consequences for your personal finances.
You've got it all, right? The brilliant idea, the perfect partner, maybe a friend you've known for years, and you're just buzzing with excitement. You're ready to go. But wait, just hold on a second. Before you even sketch out a logo, there's a fundamental decision you have to make that will define everything, especially what you stand to lose.
Look, this isn't just about some boring paperwork you file and forget. This is the bedrock, the foundation of your entire business. The choice you make right here is what builds a wall to protect you or leaves the door wide open for disaster. So let's break down the two main options in India, starting with the classic model. For, the better part of a century, the Indian Partnership Act of 1932 was pretty much the only game in town. It's the old school, traditional way of doing things, and thousands of businesses were built on it. But let's take a closer look at what that actually means for you and your partner. Okay, so you read the legal definition, and it seems pretty straightforward. Share the profits. Yeah, makes sense. That's why we're in business. But it's that last little phrase that changes everything, carried on by all or any of them acting for all. That one line, that's the key to this entire structure. That little phrase, acting for all, well, that's a legal concept called mutual agency. And if there is one thing you take away about a traditional partnership, it has to be this. It means every single partner is an agent for the entire firm and for every other partner. Here's a really simple way to think about it. Imagine you and your partners all share one single credit card for the business. If your partner goes out and makes a huge purchase, well, legally, you are just as responsible for that debt as they are. Every single action taken by one partner binds everyone completely. And that, as you can imagine, leads to a very, very serious risk. And here we go. This is the part of the 1932 Act that can really keep an entrepreneur up at night, because that whole concept of mutual agency, of everyone being tied together, is directly linked to a really dangerous feature: unlimited liability. Because every partner acts for all, a single bad decision, a single reckless move, or just one honest mistake made by one person, it instantly becomes the legal and the financial problem of every single partner in the firm. No exceptions. The law itself, right there in Section 25, is crystal clear. Now, you gotta pay close attention to that term jointly and severally. It sounds like legal jargon, but what it means is simple and honestly, kind of brutal. It means a creditor can sue all of you together, or they can decide to go after just one of you for the entire amount. And guess who they're gonna pick? Whoever has the most money. So, here's the gut punch. Under this 1932 Act, there is zero legal wall between your business finances and your personal finances. They are one and the same. If the business fails and owes a ton of money, creditors can and will come after your personal savings, your car, even your home to settle that debt. It's a massive, massive risk. And it's exactly this problem that a newer law was designed to solve. So, fast forward to 2008, India introduces a modern alternative, the Limited Liability Partnership, or what everyone calls an LLP. It was created specifically to give entrepreneurs a safer, more flexible option. The core idea behind the LLP is just brilliant in its simplicity. It's like someone asked, what if you could have the easy, flexible feel of a partnership, but without risking your personal home and savings? It was designed to give you that exact protection, the kind of safety you'd usually only find in a much bigger company structure. The official definition calls it a hybrid, and that's the perfect word for it. It's built to be the best of both worlds. You get the flexibility of a partnership with the absolutely crucial benefit of limited liability. This works because an LLP is legally a separate entity. Just think of it as its own person in the eyes of the law, totally distinct from you. It can own stuff and owe money all on its own. So how does that actually protect you? So the LLP structure creates that legal wall we were talking about. It's like a shield between your business and your personal life. Let's see exactly what that means when things go wrong. And this, right here, is the absolute game changer. In an LLP, if your partner makes a terrible mistake or racks up a huge debt, creditors cannot come after your personal assets. Your potential loss is capped at whatever amount you've invested in the business. Your home, your savings, they're safe.
So you're probably asking, okay, how is that possible? What happened to that scary mutual agency rule? Well, the answer is simple. The LLP Act specifically throws it out. Section 27 of the Act literally says that one partner is not liable for the wrongful acts of other partners. That one change makes all the difference. But that shield isn't totally invincible.
Now, this is really important to understand. Limited liability protects you from your partner's mistakes, not your own. You are always 100% personally on the hook for your own negligence or fraud. And if you knowingly take part in shady, fraudulent activity, as Section 30 makes clear, that shield just vanishes for you, and your liability becomes unlimited. Okay, so we have the classic model with its serious hidden dangers, and we have the modern alternative with its protective shield. Let's put them side by side to make the final choice absolutely clear. I mean, this breakdown makes the differences undeniable, right? The LLP is a separate legal entity. The business is its own person under the law. That's what creates the separation and gives you that liability shield. The traditional partnership, on the other hand, is legally inseparable from you. Now, that does make it a bit simpler and maybe cheaper to set up, which might look good for a tiny, super low-risk venture. But that simplicity is the very thing that exposes you, because without that legal separation, your personal assets are always on the line. The choice you make here has huge implications for your financial safety. And that really brings us to the final, most important question. When you choose that old 1932 partnership model, you are essentially trusting your partner not just with the business, but with your entire personal financial future. The LLP, on the other hand, creates a structure where that level of absolute life-or-death trust isn't a legal requirement. So the final choice is yours, and it comes down to this. What level of risk are you truly willing to accept?